Good morning. Today we are going to discuss or we are going to continue the previous lecture. In the previous lecture we have seen the concept of punishment, the object of punishment, and today we are going to start with the sections. In the previous lecture itself we have seen section 4. We'll revise it and we'll go further. Section 4 states about the different kinds of punishments which are being provided in BNS. One is death penalty, the other is life imprisonment, the third is imprisonment, which can be either rigorous or either simple. The fourth is forfeiture of property. The fifth is fine. These 5 kinds of punishments were there in IPC also. One new thing is being introduced, that is the 6th type of punishment, which is community service. The object of community service is what? To rehabilitate the person. See, we belong to the society. We are having certain duties toward the society. And this criminal, he is doing some you can say it cannot be pardoned. He is doing something undesirable element he is. So he is not having the knowledge of the problems of the society. So we have to compel him to see these problems and what you are doing in this society. He may be the first offender and all. So there are chances of reformation. Community service is not given for severe offences, that is being given for petty offences. 6 different sections are there in BNS which provide for community service. What kind of community service is provided? That is cleaning public areas, helping charitable organization, then teaching somewhere, or volunteering in an orphanage, visiting elderly people's home. So we are telling him, see their problems and what you are doing in the society. You are having certain duties. Got it? Community service represents rehabilitation and reintegration of that person into society again. This is not a punitive measure. This is not a punitive measure. Here you can say it is having a reformatory measure. Got it? It is not punish. It is not a punishment. We want to reform him. He is to be made accountable for his deeds, for his acts. In BNS, we are having 6 sections for which community service is there. Which are those sections? First is section 202, which relates with public servant if he is unlawfully engaging in trade. Next is section 209, that is non-appearance in the response of proclamation under section 84 of Bharatiya Nagrik Suraksha Sanhita. Next is section 226, that is attempt to suicide to compel the exercise of lawful powers, that is 226. Next is 303 subsection 2, which relates with theft of a property less than 5,000 and he is a first offender there. Okay, and he is giving the property back. Next is section 355, that is misconduct in a public place by a drunkard person. Next is section 356 subsection 2, that is defamation. These 6 sections are there. I'll repeat. Section 202, section 209, 226, 303 subsection 2, 355 and 356 subsection 2. These 6 sections are there where we are having community service. A good step we have taken for introducing community service for these types of simple offences, you can say, not that severe offences. However, there are certain challenges here. Complete discretionary power is with the judge to determine the number of hours of community service and other conditions and what type of community service he has to face, that criminal has to face. That complete discretionary power is with the judge. So what are the challenges here? Socio-economic factors may be affected. That should be considered. Second is the cultural diversity which we are having. That also should be taken into consideration before awarding community service. Next is the existing legal structure or the lack of procedural clarity. There is no clarity about how the community service is going to get monitored. This needs some clearer guidelines. A proper framework should be there. So the judge also can give in a proper manner the community service. We have to provide for proper clearer guidelines and structural framework for community service which are going to guide the judge while awarding community service. But it is a good step, though challenges are there, we are going to face it, don't worry about it. We are going to come out of that, and it is a good step taken by BNS. This is section 4. Okay, now next is section 5, which states about commutation of sentence. Commute means what? Changing one punishment into the other. That is commuting death penalty into life imprisonment. We are having these provisions in Bharatiya Nagarik Suraksha Sanhita also. Therefore, it is clearly mentioned in section 5 that while imparting or doing commutation, the appropriate government has to see section 474 of Bharatiya Nagarik Suraksha Sanhita, and accordingly the appropriate government without the consent of the offender can commute the sentence from one to another. Okay, now what is appropriate government? Appropriate government means either the central government or either the state government. This is section 5. Now section 6 tells about the fraction, how we are going to calculate the fractions. For life imprisonment, means the fraction of terms of imprisonment of life shall be 20 years unless otherwise provided. Life imprisonment means 20 years. We are going to calculate the fractions as 20 years. It should never be less than 20 years. However, other laws are there where we consider that life imprisonment may be 14 years if the government considers it. Okay, if the government considers it of remitting it after 14 years. That is a procedural matter. So we have to follow that law also. In Bharatiya Nagarik Suraksha Sanhita, we are having these provisions. So in harmony of BNS and Bharatiya Nagarik Suraksha Sanhita, we have to interpret the provisions. Therefore, here in section 6, it is clearly mentioned that while calculating life imprisonment, the fraction should be taken as 20 years. Got it? This is section 6. Then section 7 states that whenever in BNS it is mentioned that the offender for this particular offence will be punished by imprisonment of either description. Means here the discretionary powers are with the judge. Either description. The judge can give either rigorous, either simple, or partly rigorous and partly simple. This is section 7. Next is section 8, which states about amount of fine. Now, provisions relating to fine are being mentioned in section 8. And what are those? Like it is mentioned that in BNS, wherever the specific amount of fine is being mentioned, the judge has to give that fine. The judge can't go below the minimum fine. The judge can't go above the maximum fine. But wherever there is no limit of fine, it means it is unlimited. The judge can give any amount of fine then, but it should not be excessive. Got it? That is the first rule. The second is in default of payment of fine. Means if the judge sentences the offender to pay fine, but the offender does not pay it, he makes a default, then he will have to suffer imprisonment. That is the second rule. And the third is this imprisonment shall not be exceeding 1/4 of the maximum. Like we'll take an example. If 2 years is the maximum imprisonment punishment for a particular offence and fine, the judge has given him imprisonment and the judge has passed an order for fine also. In that case, if the offender does not pay the fine, then he has, in default of that fine, he has to undergo default imprisonment, which should not be 1/4 of that punishment. 2 years, we took an example of 2 years maximum imprisonment. So for 2 years, 1/4, that is 6 months. 6 months will be the imprisonment to be awarded as a default. He has made a default for payment of fine. That is the next rule. The other is like in default imprisonment, how it should be, whether it should be rigorous, whether it should be simple. Then it is a rule like it can be any of. That is a discretionary power of the judge. Now if there is a limit for fine, then the judge has to give that limit. He should not go above the maximum, below the minimum. Where there is no fine, no amount of fine, then the judge is having unlimited powers. But the amount of fine should not be excessive. Next, second rule is what? In default of payment of fine, the offender has to undergo imprisonment. And the limit of that imprisonment is 1/4 of the maximum. This default imprisonment either can be rigorous or either can be simple. Now, if the offence is punishable with fine or community service, and the imprisonment in default of these cases, there is a chart, you can say. They have put certain limits. Like if there is a community service or punishable with fine, then 2 months when the amount of fine is up to 5,000. Means if the fine is up to 5,000, if the fine is not paid, then the judge has to give him 2 months imprisonment. Got it? Now if the amount of fine is 5,000 to 10,000, then the judge has to give him 4 months imprisonment. And in the other cases, that is about 10,000, the default imprisonment should be 1 year. I'll repeat. If the offence is punishable with fine only or community service, the imprisonment in default of fine should follow these rules. If the amount of fine is up to 5,000, then 2 months default imprisonment. If 5,000 to 10,000, then 4 months default imprisonment. If it is above 10,000, then 1 year. Got it? Now this we have to follow it. If the amount is paid, means he has been put into prison for not payment of fine, and if the amount is paid, then he will be released because he has paid the fine. But we have to here see that how much proportion he has paid. Means according to the proportion, the amount of imprisonment will be reduced. Means we have to calculate here in a proper manner. If he has paid half the amount of fine, then his imprisonment will be reduced to half. If he has paid the whole amount of fine, then he will be released. Got it? In this lecture, we have seen from section 4 to section 8. In the further lecture, we'll go for the other sections which provide for punishment. Okay, bye bye. See you in the next video.